Does it violate the Sixth Amendment right to a public trial to close the courtroom due to intimidation by spectators? To find out, you have to read People versus Reid, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Reid. The citation for this case is 2023 New York Slip Opinion 02755, published by the New York Court of Appeals on May 23rd of 2023. The issue in this case is whether the Sixth Amendment right to a public trial is violated when a judge closes the courtroom to all spectators as a result of alleged intimidation. To understand how this case fits in and the law behind it, you have to just understand a little bit about what the Sixth Amendment right to a public trial means. The Sixth Amendment has a variety of aspects, including compulsory process and the right to confront your accusers. But one of the parts of the Sixth Amendment talks about the right to a public trial. And there's a presumption of a public trial. And in fact, the presumption can only be overcome when unusual circumstances necessitate it. That's what the cases have said. And there's 2 important cases that discuss the Sixth Amendment right to a public trial. And they both happen to relate to Georgia. They're Supreme Court cases, U.S. Supreme Court cases, Waller versus Georgia and Presley versus Georgia. Waller versus Georgia talks about the factors that a court has to consider, a judge has to consider before granting an application or before actually closing a courtroom to spectators and depriving the defendant of a public trial, a trial where members of the public can sit and watch the witnesses testify, the cross-examination, and make sure that it's fair. And basically, the criteria includes that the party seeking to close the proceedings must advance an overriding interest that is likely to be prejudiced. The closure must be no broader than necessary to protect that interest. The court must consider alternatives to closure, and the court must make findings adequate to support the closure. That's the case of Waller versus Georgia. And the second case, Presley versus Georgia, is a case that says that it talks about the importance of creating an adequate record. And it says basically the particular interest and threat to the interest must be articulated sufficiently, along with findings made specific enough that the reviewing court can determine whether the closure was proper or not. So that's the background to the public trial requirement. What are the facts of this case? The facts are that in this particular case, the defendant is charged with murder 2, a second-degree murder, and 2 counts of second-degree weapons possession. During the trial, the defendant there's several things that happen that are related to intimidation by members of the public, by spectators. Photographs were taken in the courtroom, which is against the rules, of the defendant with court officers and were posted on Instagram with a caption saying "Free Dick Wolf," which is alleged by the people to be the defendant's street name. Additionally, people on the defendant's friends allegedly were staring people down in the courtroom. A court reporter in the case was intimidated when members of the defendant's group or people associated with the defendant talked to her before she got in an elevator and asked if she was afraid to get in the elevator with them. Basically, these were all brought to the court's attention, and the court makes a record of these series of incidents, and then basically says, "I'm going to close the courtroom to spectators as a result of the cumulative effects of these various factors." The defense counsel objects and says, this is a violation of the Sixth Amendment right, and proposes banning cell phones. So that's the alternative offered by the defense counsel, says, bar cell phones from the courtroom if you want. But that would be unfair to exclude all spectators from the trial based upon the misconduct of individuals. The court rejects that proposal and says to prevent the jury from getting a negative inference of only excluding the defendant's friends, the court says I'm going to exclude everybody, the victim's family, the defendant's friends. And basically for the next 4 days, the public was excluded from the courtroom for testimony of witnesses, summations, and the verdict. The defendant was found guilty of everything, and the defendant appealed the courtroom closure. The appellate division affirmed it and said this is a provident exercise of discretion by the trial judge. But it goes to the Court of Appeals, and they say this was wrong. This was error. They say it was error for both of those reasons that we talked about earlier, that Waller versus Georgia and Presley versus Georgia. Waller versus Georgia said the court didn't adequately consider all the criteria, all the factors, that the court didn't adequately assess the reasonableness of the alternatives to closure, that there's no record of discussion with the actual offenders no evidence of actual witness intimidation, and only vague descriptions of the purportedly intimidating conduct. And finally, they say with respect to the record here was insufficient. The court didn't make a sufficient record to actually close the courtroom based on these events. But finally, the Court of Appeals says, but they make it clear witness intimidation or intimidation by members of the public is theoretically a sufficient ground to close the courtroom to spectators. But in this particular case, the record was deficient as to the proper inquiry being conducted, and the record was not sufficient, showing that the judge properly considered all the alternatives that were less strict than just closing the courtroom to all the public. So that's the case of People versus Reid. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.